If you don't plan, you're stupid.
Welcome back to If You Don't Plan, You're Stupid with estate planning attorney Andy Rosenberg, a Florida-based lawyer who helps families protect their legacy and avoid costly legal mistakes. I'm John Clemens. Today, we're talking about medical decision-making. We'll discuss who gets to speak for you if you can't and how to protect your dignity when it matters the most. But first of all, Andy, friend, welcome back to the show. I'm excited to talk with you today.
Hey, John, it's always good to talk to you, and it's a Friday, so it's always nice to talk to you because that means we're almost done for the week.
Oh, for real. I can't wait for my weekend. But anyway, that's a different podcast. We'll do that one next. So let's dig into the topic at hand. And the first thing I want to know from you, Andy, is what's the difference between a healthcare surrogate form and a living will?
Okay, that's a great question, and I get it all the time. In fact, I'm gonna tell you one further on this one that you probably didn't even know about.
I guarantee I didn't know about it. Go ahead. Yeah, I'm excited to learn.
Okay, so let's talk about healthcare surrogate, living will, and DNR. How's that?
Oh, okay. All right.
All right, so here we go. A healthcare surrogate. We've talked about it a little bit in other podcasts, but remember when we talked about in a prior podcast, if you become disabled or incapacitated and you can't handle your financial affairs, there's a document called a durable power of attorney, right? So the same document or the same scenario where you're disabled or incapacitated, but you can't make healthcare decisions. That is a healthcare surrogate. So again, the durable power of attorney is for financial. Healthcare surrogate, unable to make decisions for yourself, that's a healthcare surrogate. I'll give you an example of how it works in a minute. But then let's talk about another document, the living will. And I'll tell you an example of that as well in a minute. The living will is also called, at least in Florida, and what I call a dying with dignity document, the pull the plug document. If you remember the Supreme Court case way back when, the Terry Schiavo document.
I remember it very well. Yeah.
You remember that?
I do.
Yeah, it was between. Yeah, it was. If you remember, it was between. I believe it was her parents and her husband, and it went all the way to the Supreme Court. Who had the right to decide to pull the plug or not pull the plug? So that's a living will. And then the third document is a DNR. It stands for do not resuscitate. Now, I want to delve into this a little bit further, John, if you give me a few minutes here.
You bet. Go for it.
Okay, so I'm going to give you examples of each. Healthcare surrogate. John, let's say that, God forbid, you're in a car accident and you get rushed to the hospital by ambulance and you're unconscious. And let's say you broke your arm, okay? And the doctor that's looking at your arm, at the ER doctor, has determined that we could do surgery, not do surgery, and there's a couple so there's 3 to 4 options that he would like to talk to you about. And the problem is, do you want surgery? Do you not want surgery? We got to figure out what to do. The problem is you're not awake. You're in the emergency room, knocked out from the car accident. We got to make decisions. So who can legally stand in your shoes to make the decisions? That is the healthcare surrogate. And that hopefully visually it makes sense. Now, let's switch gears. Let's talk about the living will. Again, that's the dying with dignity document, the pull the plug document, the Terry Schiavo document. I like to describe it in this way. God forbid you happen to get in a car accident again, John. You're just a crappy driver, okay? So you broke your arm a couple months ago. Now you get in a horrible car accident. You get rushed to the hospital. Again, you're unconscious. And the doctors are running all these tests. And they determine that you cannot breathe on your own anymore. It's a struggle. So they have to put you on the tubes and ventilator. So now you're on the tubes and ventilators. They're running all these tests. One of the tests comes back and it says that you're brain dead. In that situation, the doctors are going to say there's nothing more we can do in this point in our professional opinion. And the only thing keeping you alive, John, is that ventilator. Then that's when, at least in Florida, that's when the living will kicks in. And we look to see whether you wanted to stay on life support or you wanted to take it away in that situation. You see the difference between a healthcare surrogate and the end stage living will situation?
Yeah.
Does that make sense?
That makes sense, yeah.
Yeah, big difference. And here's what you need, at least in Florida, what you need to understand with the living will, it only kicks in when doctors have determined first medically in their professional opinion that there's nothing more that they can do, like the situation where you're brain dead. Okay. Now, let's take it one step further and let's now talk about a DNR, because people think that living will is a DNR, and it is not. It's completely different. So, DNR stands for do not resuscitate. So, imagine, John, that you and I are in a room together and you have a massive heart attack and you drop dead right then and there. I'm going to do whatever I can. I'm going to drop to the floor. I'm going to do compressions and stuff and try and get you back to life with CPR. If you had a DNR and I knew about it, I could not do it. So there's a famous, when I was in law school, which was forever ago, 30 plus years ago, I remember the case. There was a case, I forget the name of it, but it was how I learned about DNR. It was a biker. Imagine a biker, a big burly guy with a vest, only a vest on, hairy chest everywhere. And he's at the bar drinking beers and all that stuff with everyone else in this biker bar. He gets up, starts walking, and then just drops dead. He's having a massive heart attack right then and there. There happened to be an EMS person right there as well. EMS immediately jumped to the floor, ripped his vest open, and was getting ready to start compressions, and then he couldn't. You want to know why he couldn't? Take a guess.
I'm assuming he had like a tattoo or something that said DNR on him.
Exactly. He had a tattoo on his chest that said "Do not resuscitate," and he couldn't do it. So that's a true story. That's a case. That's how it came about. So again, the difference between a healthcare surrogate, a living will, and a DNR. I hope that made sense.
That did, and I appreciate that there's all these different forms and all these different scenarios. And maybe I come to you and say, Andy, I don't want to deal with all that crap. Look, I've been married to my wife for 20 years. She's my best friend. She knows me better than anybody. If something happens, I know she'll make the right decision. Like, why can't that just be enough?
Unfortunately, that happens more than you want to know, John.
I can imagine, yeah.
Yeah, it happens a lot. And my answer is it's never the right decision. You should always have things put in place. Let me give you an example. Let's say that you get rushed to the hospital and your wife is there and you have adult kids. And decisions need to be made, and the wife wants to do this one decision and the kids don't agree and want to go the opposite direction. What do? Who decides? The doctors in the hospital have to make decisions. What are they going to do? Well, in that situation, it's not, there's liability concerns. So the hospital, they may do nothing and say, you have to go to emergency court to figure out what the decision's going to be. Or legally, I believe in that situation, I'm not 100% sure, the wife has legal authority over the kids. But now you got family dynamics where you got opposites making decisions and they're fighting and all this stuff. I know I've recently had that happen, not with me, but I've heard of a client have that happen. Not my client, but they came in after the fact, and it was like that. And the hospital refused to do anything. They said, get the court to make the decision. We do not want to be held liable. So my answer to your question is, my answer is always have it. Get it in place, guys. It's really important. You don't want to put family in awkward situations or the professionals in an awkward situation.
Yeah, especially if I'm the one, lying on the hospital bed.
Yeah. You know what? Let me tell you a story. So, I recently had kidney stones, and I had to have kidney stone surgery. It was horrible. So when I get to the hospital, what do you think the first question is that they're asking? Any idea?
No idea.
Okay. The first question they're asking is, do you have insurance? Because they want to make sure you get paid. So that's the first thing. But the second question is, do you have a healthcare surrogate? Third question, do you have a living will? That's how important it is.
Wow. Well, first of all, I'm really sorry you had kidney stones, because I had those one time and they're the worst thing I've ever experienced. So my apologies for that.
I agree with you. They are the worst things you can experience.
They're terrible. There's no redeeming qualities. But I think to your point, though, that's how important these legal documents are. I appreciate you bringing that to the fore. I did have a follow-up question, though, with that. You mentioned, like, let's say that I am the one who's in the hospital and I have my wife and my kids and they can't agree. Is this something that could be avoided if you only name one of them as a surrogate, or can you actually name more than one person as a surrogate? Like, how does that whole dynamic work?
That's an awesome question. And the answer is both. You're correct on both. So the scenario is you can name multiple people as co-healthcare surrogates together, but my recommendation is name an odd number. Okay? Because if name one or name three or five or whatever you want to do, or name one and an alternate and then another alternate. Because if you name, let's just say that you have 3 kids and a wife, and you name all 4 of them together, okay, as co-healthcare surrogates for you. We have an even number. What happens if 2 go one way and 2 go another way on a decision? That's a
Now
problem.
you're stuck. Yeah.
You're better off getting an odd number or one and then alternates, in my opinion.
Yeah, that sounds like a better plan to me as well. And just for the record, it's gonna be my wife, not my kids. Sorry, kids, love you, but be my wife. I do want to
I got a
know.
funny story. Wait, I
Yeah.
have a very funny story about that because you mentioned it. So I used to have 2 dogs. Okay, I have Gary, my my Labradoodle, right? And then I used to have Morky. His name was Morky. He was a Maltese Yorkie mix. And I had to put him down about a year and a half ago. He was 16 and a half years old. Bear with me, John. This story you'll like. So when he was 15 years old, Morky, he was starting to go the other way, not doing well. And my kids and my wife basically said, Andy, I think you need to put him down. And I'm like, I don't think I need to put him down. I go, he still follows me around the house. When he wants treats, he knows where to go to get treats. He's still eating and all that stuff. I'm like, I don't think he's ready. So I said, I took him to the vet. And this was my therapy dog. Like I took him to the hospitals as a therapy dog. It was great. He was awesome. So my vet loved him because he was the only one that he's had that did therapy for people. So I took him to the vet at 15 years of age, and I said, listen, do I need to put Morky down? What's the story? Is he in pain or whatever? And he looked at me and he goes, listen, I won't object if you want to put him down. And I said, that's not my question, doc. I said, my question is he in pain and do I need to put him down? And he says, he's not in pain. And if you don't want to put him down, I would totally respect that. But I also respect if you want to just put him down. I said, no, I don't want to put him down unless he's in pain. He said, no, he's not in pain. So I brought him home, much to the demise or to the dissatisfaction of my 2 kids and my wife. Brought him home, and he starts peeing and pooping all over the place. So you know what I did, John? I put him in a diaper, and he would wear a diaper every day. And then every night, I'd come home, and I'd take off the diaper. I'd give him a shower or a bath, and I put him in new diapers, and that's how I did it. I did that for a year and a half till he was 16 and a half years old. So we're all at the dinner table one night, and I think he was probably 15 and a half to 16 years old at the time, Morky. And he's walking, losing weight. He's very thin now, but he's still walking around. He's got his diaper on. My wife looks right at me and she goes, I want to change my healthcare surrogate. I go, what? She goes, look at Morky right now. I said, yeah. She goes, that's me. If you were to treat me like that, I would want to be dead. What are you doing? So she said, go get me a new healthcare surrogate and name my daughter, who's a nurse practitioner, the healthcare surrogate. So you know what I did? I told her to go find another attorney. So at this point, she's yet to change it. It's still me as the healthcare surrogate. But you brought up the point. I named my wife. She named me, but it doesn't always have to be the spouse.
That's
The
hilarious.
moral of the story is make sure you know someone that you trust will make good healthcare decisions for you.
Oh man, tell me you've been married 30 years without saying you've been married 30 years.
I've been married 32 and she still puts up with it. Hey, another point I want to bring up for you real quick.
Yeah.
Very important point, actually. The healthcare surrogate and the living will. You can have, let's say you have a healthcare surrogate and you don't have the living will, okay? I call that, in that situation, I call the healthcare surrogate the God document. Why? Because whoever you named as the healthcare surrogate, you're giving them the ability to decide if you live or die if you're ever needing to be put on life support. The difference is if you have a living will, you're telling everyone now what your wishes are so that if it ever happens, we know what your wishes are and we have to honor that. Big distinction. I will tell you, after 30 plus years of practice, I get more calls for thank yous saying thank you for having that durable or the living will in place. We knew mom, dad, brother, sister. We knew what their wishes were and we didn't have to contemplate it.
Yeah, I know my dad experienced the same thing when my grandmother was at the end of her life. To be able to know what to do was just a stress relief, like, you know, you can't even imagine.
Yes, yeah.
Yeah.
Listen, it's a horrible scenario. You hope no one has to go on this end of life situation. But if you do have that situation, to know what their wishes are is a blessing.
Yeah, absolutely. And I do have one more question. We're running a little run short on time, but I want to get one more question in. What happens in the case that maybe the surrogate wants to take one course of action, but maybe the doctor would recommend something else, and maybe the family would recommend something else? Like how does that situation play out?
Yeah, that can get very complicated very fast. So here's my advice. Number one, try and communicate with the doctor and the healthcare surrogate and find out where's the disconnect and to see if they can figure out what's going on to get to the common ground so that it can work. That's always the best avenue. Number two, if that doesn't work, then consider hiring an ethics consultant or a palliative care type person and let them almost become the mediator so that they can get involved and really hear both sides of the story and then have them help make a final decision that everyone can agree with. If that doesn't work, then you may have to consider getting an attorney and having legal courses of action involved, which is obviously never a scenario that you want to go into. The last resort would be if you know that you have this problem and that they may not make the right decisions, try and remove the healthcare surrogate and get another healthcare surrogate appointed. I mean, it doesn't happen very often. That's why it's really important to talk to the person or persons that you're naming as your healthcare surrogate and make sure that they know what your wishes are and your thought processes are so that they're on the same page as you. If they're not, then maybe they shouldn't be your healthcare surrogate.
Yeah, that sounds like really strong advice. Well, Andy, there's so many more questions I could ask, but we're running short on time. Maybe I'll have to come to one of your seminars to learn more. Who knows? But so I do want to thank you though for coming on. Yeah, and just sharing. This is such important information. It doesn't get talked about enough. So I'm glad we're having this conversation today.
I appreciate you, John. You make it easy to talk to.
And to our listeners, don't leave your care or your dignity to chance. Visit rosenberglawfirm.net to create a clear plan for your health and your legacy. And of course, don't forget to share, subscribe, and leave a review. And with that, I hope you have a great day.
Take care, everybody.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.